building our brains to understand that part. So before we start, pushing why the issue of eradication of child labor and all that, there's more proclamation towards eradication of hazardous labor, right? But which has not really played out in most literatures that people have written, and there are two reasons for that. One is that they might not have interacted sufficiently enough with the context of international law, the African Children's Charter, for example, or the UNCRC. That if not also interacted a lot with cultural context on this subject matter. I'd like to appreciate the fact that the law does not prohibit a child from working, but the law prohibits a child from being involved in hazardous work. We need to understand these two elements, that the child can work, but should not be involved in hazardous work. And if you look at the provisions of the African Children's Charter and the UNCRC, it does not actually mention age again. It doesn't mention age, that a child should be born in labor. And this is, of course, I will agree with you that most of us were in shops. Some of us were headsmen. Some of us did all sort of work, right? And even our children now still do some work. If you ask them, my daughter's 9, and when she starts playing on her iPad, you call her to come to tell you, I am busy. And for that reason, and that responsibility, it becomes an adult-framed issue. But then children are involved in this space. So the question is whether, if we look at it in a very contextual situation, do we have situations where the children work without a provide? In this context, I'll say yes. And this is especially in children's or child-headed homes, right? You find them in child-headed homes, some people do not ignore the fact that we have those realities in this context. You find them in child-headed homes where some of these senior children in the context of their family involved in work in order to care for the other ones. They're almost the same. They don't speak about age. There's no age. As I said, there are two things. The child should not be allowed to, to work, not work that is wages, or whatnot, especially work that is hazardous. That part is prohibited. We were involved in during the 35th session of the African Children's Committee. During that meeting, one of the things that we're discussing, especially around child labor, was the fact that if we contextualize the phrasing of the African Children's Charter, it doesn't really prohibit child labor. And because we have to just oppose it with the realities in the continent, as Alan put it very strongly. The fact that if you have to be involved, our cultural dimensions, most of our cultures, they allow us to be involved in such spaces in most villages, and this is not our problem. But in the issue of the age, you have 12. These are children that are highly dependent on their families, on their parents. They're dependent on adults. Between the age of 12 and 15, these are children that develop different ideas. They want to sleep out, as they call it, night over, sleepovers, yes. They want to have sleepovers with their friends. They start having conversations in that space, with their friends. Now they're teenagers, they be involved in different activities. And right here, to the age of 14 and below 18, these are different groups of children now. And these are children that can also they have their own ideologies. They have their ideas. And when you as a parent speak to this child, tell you, no, I don't agree with what you're saying, because this is my own perspective. The first is conflict and poverty. Most parents have been killed in wars and all whatnot conflicts. We have child-headed households. Migration and IDPs, you have children that move. We have a children in this country now that move. Some with identity cards, with IDs, and then they move to the country. They are forced to work in order to survive. You have increased informal level step up, because most of our work, as Alan was saying as well earlier, is that legislation in most parts of this continent legislates or regulates industry. It doesn't regulate informal work. And most of our parents are involved in informal work, agriculture, fishing, mining. You can call it category, so many other things. And most of us get involved into that space. So it becomes very difficult to tell a child in that particular community that they not work. And that's what the law will then come into play, because there's no law that actually stops the child from such spaces. Next one is the impact of climate change. And here, the reason why I brought this up, and environmental shocks, is that one clear example was in Durban, here in South Africa, where because of climate change, a lot of rain, had a lot of floods. So adults could not cross, go over that road to go to the next side. What happened? Young guys, very young boys, 14, 15, will come and then try a way of picking you up. And then they walk across, and then you give them money. Right? These are things that happen in most of our countries. They take you across, the little, water there, and then you give them money. We saw it in Madagascar, we saw it in Mozambique. And I didn't get to go to Blantyre when the children were put in the camps there. I ended up in the local area. But I'm very sure that something like that would have happened there as well, in terms of children interacting and helping others to close. But then we have COVID-19 as well. I also heard Milka mention something of that nature around COVID-19 and trafficking. You can also have the issue of child labor, where adults are gone or dead, or the fact that they could also stay at home, or the closures of schools, increase these other issues of child labor. And then we have parental responsibilities and legal requirements to promote culture and positive
Simplest questions rather to answer are actually the hardest. For example, if I say, who are you? It's a very simple question, but a very difficult answer. Because when you think, who are you? Someone says, oh, I'm Landilani. That is your name. Is that who you are? You say, oh, I'm a lecturer. You know, that's your work. Is that who you are? You see. So when people then begin to have a certain sense of identity, they intrinsically feel that that is their sense of belonging, and they guard it so well. Now, when you have a collective of people having that sense of identity, they want to guard it very, very well. But then they also have leaders who think that this is the identity that we have. But I define heterosexual nationalism as a form of governmentality. I start with that. And by that, I'm borrowing from Foucault, who talked about governmentality. And when I talk about governmentality, it's about how government rationalizes its decision. So one of the things is that when it comes to issues of sexuality, heterosexual nationalism as a form of governmentality perceives Western countries as an enemy when it comes to human rights. It looks at them as trying to import their cultures and their values into the nation or into Africa. And that is then contested because it feels like an insult to the national identity. Another thing is that it is sustained by the state, because it is the state that sustains the policy, but it is driven by so many other actors. It is driven by religious leaders, it is driven by cultural leaders, it is driven by, you know, moral leaders and so on. And then it rationalizes the existence of anti-sodomy laws as very important to preserve the heterosexual national identity. Another thing it does is that it rationalizes the impact, the negative impact of anti-sodomy laws as legitimate, because it doesn't see sexual and gender minorities, and which is based on the narrative that Africa is organically heterosexual and that all forms of diversity do not exist, and that, you know, pre-colonial African societies were never sexually diverse. But in contesting it, their argument is that that is a wrong narrative because it is not founded in history, and also not based on any historical evidence. So the vast majority of literature will show that African culture is actually sexually diverse. A lot of the writings of the anthropologists says that, you know, the continent is very culturally, sexually diverse, and that my argument is that when you look at the map of Africa, it is actually a topographic creation. The countries are really, really blurred. I mean, if you look at Malawi, Malawi is actually in Zambia, isn't it? No. We are not going to. It's like the argument we have Malawi. You don't say Zambia is in Malawi, but it's actually there. But Zimbabweans will say the Victoria Falls is in Zimbabwe. It's actually, you know, like. But anyway, but these jokes are actually very telling of how colonialism disrupted, you know, the culture that we have. And my basic argument really is that colonialism disrupted the culture of tolerance and acceptance of sexual and gender minorities. Because if you look at the anthropological writings, they would say that all African cultures were tolerant towards sexual and gender minorities. And I cannot get into that now, but that is what the literature says. But what happened is that colonialism brought a new way of thinking and a new way of socialization. So our systems of socialization in the community were disrupted because it brought with it, you know, different forms of teachings, Christian moral ethics, and so on and so forth. And those teachings really disrupted the way we thought. So it's about the harm principle. So irrespective of the fact that the cultural nationalists will argue that no, this is uncultural, but what is and culture be a subject of criminal law? The argument is that it should not. Why? Because culture is very constructed and it is very subjective. So should those subjectivities be a matter and a subject of criminal law? So my argument is that it shouldn't. This is to just conclude. So how many minutes? I wanted to argue here that in pre-colonial African societies and Zambia, it was very diverse, right? But when I look at the map of Africa, if you look at the Ovambo, now in Angola and Namibia, you will find that they came from what is northwestern Zambia. So they moved. If you look at the Tonga of Southern Province, they moved also to Zimbabwe. The map of Africa, we were very nomadic because of war, because of looking for grazing land. And as people moved, they took with them their culture, they took with them their religious beliefs. And as such, the culture of sexual diversity was widespread and existed throughout the continent. So when someone argues that in Zambia there is no sexual diversity, I find that to be an argument. And then we have to reclaim this culture of tolerance and acceptance, which is what I call the shared value. The actual shared value of African culture is not what the AU is saying. It is actually the culture of tolerance and diversity. And I conclude again, contesting heterosexual nationalism towards the protection of the rights of sexual and gender minorities requires decolonization and decoloniality. I think from what I've said, we can pick up the decoloniality and the decolonization perspectives, and I'm out of time.
Human rights laws at the African regional level address the intersectional challenge of refugees, intersectional challenge that refugees face regarding housing. The right to live somewhere in peace, security, and dignity. And this right is applicable to everyone. Everyone is a holder of this right, regardless of whether a person has the financial means or not. So the violation of this right also has adverse implications on the realization of other rights, such as the health, which is very closely related to the right to housing. As you can imagine, a person who lives in a dilapidated house is more likely to develop illnesses and other violations. You know, private landlords are less likely to allow you in their premises or to lease houses to you if they think that we're likely to cause problems at the later stage. Refugees who are unaccompanied children, refugee women, older refugees, refugees living in poverty, and refugees living in refugee camps have intersectional challenges related to housing, which other refugees or other people do not face. These challenges can sometimes be compounded. Because the OAU Refugee Convention is a specialist treaty that makes specially regarding refugees, we should first look at its provisions on housing and refugees in order to establish their legal status as well as what kind of protection it affords to refugees. So the problem is that the OAU Refugee Convention does not have a provision specifically dealing with the right housing, but it is a complementary treaty to the UN Refugee Convention. So complementary means secondly, this is limited because it acknowledges differential treatment between refugees and other groups, and even within refugees, because it excludes refugees who do not meet the requirement of lawful stay in the asylum state. Thirdly, the protection that it affords is a relative standard. It depends, the extent of protection depends on the extent that a state accords to aliens generally in similar circumstances. So it's not an absolute standard. It's not an absolute normative standard. The Commission has also jurisprudence on refugees' rights, which I'll talk about in a moment. The Disabilities Protocol does not contain reference to refugees, but it has disability-specific provisions, which are really nice. But in that, the differences that we have in the refugees, but it doesn't mean that it cannot apply to refugees. So gaps, discrepancies, interpretive solutions. Maputo Protocol, or the Women's Protocol, uses the protection of the right housing or other rights that are accorded to refugees under international refugee law, which means that it only recognizes the relative standard which is protected under international refugee law. When we say international refugee law, it includes the UN Refugee Convention and the OAU Convention. In my view, the correct way of doing it is, instead of just going straight to the African human rights instruments, it's important to go from the OAU Refugee Convention to the UN Refugee Convention first, because it's a complementary treaty. And under the UN Refugee Convention, there is a right clausing, but it's inadequate. Therefore, what we should do is go to Article 5, which makes reference to other treaties or domestic laws which provide favorable treatment to refugees. There are gaps, they don't address refugees, discrepancies in the normative standards. This can be addressed by using the correct methods, which I will address in the paper now. While the recognition by the African human rights bodies, specifically the African Commission, which recognizes refugees as holders of the rights set out under the African Charter, is an important and progressive approach. Such recognition should be backed up with.
Sound quite abstract and far away from the human rights discourse, but we try to learn and translate ideas and concepts of Nyerere and Senghor to rethink and maybe unlearn some things that we practice and research on when it concerns human rights. So yeah, maybe when we come to the realization that those of us that seem to not be human or not enough human, according to the ideal person of being a white male heterosexual cis man, how we can challenge that and how we can ensure that the law, or maybe it is not possible, but to discuss how law might be able to protect also people that at the moment seem to be not human enough. And yeah, as I said before, we are drawing on SNEX's book, Africana Presence, that she published recently. What he saw is a correlation between a community that included everything, so was all-encompassing, and individuals who are obligated to contribute to this community with the skills they have. So that means or meant that not everyone has to do the same thing in contributing to the community, but according to what maybe one's individual skills or possibilities are. And important to highlight there might also be that this idea of everyone contributing in their own capacity and therewith being part of this community also means that there is no ladder of humanism. So no one is less or more human only because of how and what they contribute to the community. It is important that they contribute. And when turning this idea around, that also means that the community has an obligation to allow all of its members to contribute in a way that is possible to them and that is open to them. And the question we have been asking ourselves is then, okay, what happens if this obligation or this possibility is not given? So if, and often at the moment, unfortunately, it's the case that queer individuals don't have the possibility to contribute to their community in a way they could or they would want to. And due to marginalization, they are often forced to make a decision between either denying their existence and their human dignity or the opportunity to fulfill then their responsibilities and therewith being part of their community and being seen as human.
And so through negritude, what this figures behind it try to do is to accept the humanity of Black people and to refuse the Eurocentric view and notion of the human who qualifies as a human and who is rejected from that notion of the human, who is outside of that. And so that's the main agenda behind negritude movement. And we might also know that negritude has faced several criticisms from African intellectuals such as Wole Soyinka for it being essentialist, and some even accuse it of being counter-racist, but this is not the discussion we are going to dwell on for today. We're going to just pick on the possibilities it opens up in helping us think about the notion of the human, the category of the human, and the idea of the human that's embedded in the human rights discourses. When we talk about human rights discourses in Africa, which human are we really thinking about and who is excluded from that notion? And does it even make sense to talk about human rights discourses when we have people that have been excluded from that plane of humanity? And one of the ways in which negritude helps us rethink the humanity of Black people is by rediscovering our cultural civilizations as Black people. And in discovering our cultural civilizations as Black people, it enabled us to crack open African interiority that is accommodative, as you were saying in your presentation previously, that's accommodative of multiplicities beyond the binary. So Africa is beyond, or the notion of humanity in the African context is beyond this colonially imported homo hetero category. It's more inclusive to differences. It's not about even tolerating those who do not practice heterosexuality. It's so that criminalizing the inhuman treatment of the marginalized is one thing, but dealing with society that embraces the notions of the non-humanity of LGBTQ plus bodies is another, which I don't think the law can handle in and of itself unless some other things happen, as we try to think and work with the law. And so I think this is where the potential of negritude, as well as Nyerere's Ujamaa, help us to think of new humanisms, first and foremost by deconstructing the normative view of the human that centers the white, heterosexual, middle class, cis man. And then because these two historical characters or figures taught beyond the normative, that the centers this man, their thoughts became important movers behind anti-colonial and post-colonial struggles for freedom of Black people. And then how can we mobilize in our context their thoughts to kind of push it even further and think about the human rights of gender and sexual non-normative groups that can benefit only if there is a social transformation, which must begin with rethinking the gaps of who or what constitutes the human as we know it and live it today. So I think in short, we are basically saying the law is not enough because the idea of the human with which the law operates is a bit incomplete. We need to kind of rethink that and expand it a bit more.